You've built a life together, shared a home, managed bills, celebrated birthdays, and created countless memories. You've supported each other through life's highs and lows, and maybe even raised kids along the way. But here's what many couples don't realise. If you're not married or in a civil partnership, the law in England and Wales does not recognise your relationship when it comes to inheritance. Hi folks, and welcome back to Everything Estate Planning. I'm Jim from Elm Legal Services, and in today's episode we're talking about something more common than many people realise. Couples who've shared a life together but haven't made it legally binding. We'll look at what UK law really says about unmarried couples, what could go wrong if you don't have legal safeguards in place, examples of families who've been affected, and the estate planning tools that can give you and your partner true peace of mind. So let's get into it. In the UK, there is a widespread myth known as common law marriage. A lot of people believe that if you live together for long enough, 5, 10, 20 years, the law treats you like you're married, even if you've never made it official. So where does this idea come from? Well, it's partly down to language and habit. For years, people have used the term common law husband or common law wife in everyday conversations. It sounds official, like something that must exist in law. In fact, it used to exist in a few legal systems like parts of Canada or the USA, and in some American states it actually still does. But here in England and Wales, common law marriage has no legal standing at all. It's a social phrase, not a legal status. And that misunderstanding leads to real problems. If one of you passes away without a will, your estate will be distributed under the rules of intestacy. Now, these rules only recognise legally married spouses, civil partners, and blood relatives. Unmarried partners are excluded completely. So even if you've shared your life for decades, raised kids together, and consider yourself family, your partner has no automatic right to inherit anything. If the home is in your name, your partner could be forced to leave. If your savings are in your account, they may not get a penny. It's not just unfortunate, it can be devastating. As an unmarried couple without the right legal planning, everything you've built together could be at risk. Let me tell you about Dan and Emma. They've been together for 12 years and they lived in the same flat, split the bills, and even raised Emma's son from a previous relationship as family. But when Dan passed away unexpectedly in his early 50s, everything changed. Dan didn't have a will, and the flat was in his sole name, and legally Emma was entitled to nothing. Dan's estate passed to his estranged brother, someone he hadn't spoken to in over a decade. Emma had to leave the flat, and then she spent months dealing with grief and legal stress, all while supporting a teenager. And the saddest part, it was completely avoidable if Dan had planned properly. So what can you do today to protect the person you love? Number 1, make a will. This is the most important step, the foundation of your estate planning. A legally valid will allows you to clearly name your partner as a beneficiary and specify exactly how you want your assets to be distributed. This means you decide who inherits your home, savings, possessions, and other important assets and belongings. Without a will, the government applies strict rules that do not recognise unmarried partners. And in that case, your partner could be left with nothing, no matter how long you've been together or how much you've built as a couple. Making a will ensures your wishes are honoured and your loved ones are protected exactly as you intended. Number 2, consider setting up a trust. Trusts offer an added layer of protection, especially when family situations are more complex or when you want to make sure your assets end up in the right hands. For example, imagine you want your partner to stay in your home for the rest of their life, but you also want your children, perhaps from a previous relationship, to inherit that home eventually. This is exactly where a property protection trust can help. Take Carol. She wanted to make sure her partner Ben could continue living in their home after her death, but also she wanted her son to inherit the property in the long run. By setting up a trust, Carol ensured that Ben had the legal right to remain in the house for his life, but ownership of the home would pass to her son later on, just as she intended. Now, this kind of planning is particularly important if the surviving partner might remarry in the future. Without a trust, assets could unintentionally be passed to a new spouse or their family, rather than to your own kids, a risk known as sideways disinheritance. A trust protects both your partner's security and your children's inheritance, making sure your wishes are carried out no matter what the future holds. If you'd like to know more about sideways disinheritance, we've made a video dedicated to the subject, which you can find in the description below. And number 3, arrange a lasting power of attorney, or LPA. Estate planning isn't just about what happens after you're gone, it's also about protecting yourself and your partner during your lifetime. If you become seriously ill or lose the ability to make decisions, your partner has no automatic right to step in on your behalf, even if you've lived together for years. That's where a lasting power of attorney comes in. With an LPA in place, your partner can legally manage your finances and make important decisions about your healthcare, even if you're unable to do so yourself. It gives both of you peace of mind, knowing that the person you trust most is legally empowered to act in your best interests. Let's recap what's at stake. If you don't prepare in advance, your partner could lose the home you shared, get nothing from your estate, and be shut out from decisions about your care. None of it would reflect what you actually wanted. You've built a life together, you've shared everything. Please, don't let a lack of paperwork undo all of that when it matters most. At Elm Legal Services, we've helped thousands of couples across England and Wales get the peace of mind they deserve. We'll work with you to draft a legally valid will, set up the right kind of trust for your needs, put powers of attorney in place, and make sure that your estate plan reflects your wishes, not the assumptions of outdated law. There's no pressure, just clear advice in plain English. If you're in a long-term relationship but not married, now is the time to act, because without a plan, the law doesn't care how much love or history you share, but with the right plan, you can protect your partner, your legacy, and your peace of mind. If you're ready to take the next step, click the link in the description to book your free, no obligation consultation with one of our professional advisors. We're here to help because estate planning isn't just about assets, it's about the people we care about. Thanks for joining us today, and if you found this video helpful, please give that like button a friendly handshake, subscribe, and turn on notifications so you're the first to know when we upload a new video. And if you know anyone who might find this information useful, please consider sharing it with them. The more we can raise awareness about the importance of estate planning, the more families we can help avoid unnecessary stress, uncertainty, and heartache down the line. Remember, a little planning today can make a big difference tomorrow. So until the next time then, stay safe, stay informed, and stay tuned.